Have I got the right, excuse me, I got the right one. Senator Cooper, excuse me.
Here.
Senator French,
Here.
Senator Kolb,
Here.
Senator Cost,
Here.
Chairman Nethercott.
Here. All right, we will start this morning off with Senate File 98, bail source hearing. Senator Ellis.
Thank you, Madam Chair. With your permission, I would like to ask a member of the Cheyenne Police Department to come up here. I think he'll be able to answer some of the questions that you have about why this bill is needed. And so I thought it might expedite the discussion a little bit more.
Certainly, Senator, please come forward. Do you want to walk us through the bill?
Yes. So Senators, before you, you have Senate File 98, which deals with bail source hearings. And I just want to keep you on a very high level of why this bill came. Imagine you have two individuals who rob a gas station or a bank, and the police are able to apprehend one of them, the person who doesn't have the cash on hand, but the other person got away with lots of money. And so the person who's arrested, is pending legal charges in a court. And when it comes to setting their bail, a large amount of cash shows up to allow that individual to post bail and get out. And the judge and the police and the prosecutor think, I wonder where this cash came from. Did it come from the robbery? Where did this money come from? I think most of us in our core would say if it came from the robbery, that's not fair. And so that's what this bill is trying to get after. We see this in other states, and I'll let, this is Detective Casey Patterson with Cheyenne Police Department. He reached out to me during the interim and explained how this situation is growing in numbers in our community. And at the end of the day, we just don't think it's right. So to walk you through the bill, what this would do would create a new section in Title VII, allowing a circuit court or district court to conduct a hearing and may or enter orders necessary for the purpose of, turning on to page 2, ensuring that a defendant does not use or has not used any proceeds directly or indirectly derived from a criminal offense to use as cash, appearance bond, or other security for bail. And then section B says, before entering an order admitting a defendant to bail, the circuit court or district court may require the defendant to provide documentation or other evidence of the source of cash, bonds, or sureties that would be used for bail. And so moving on, it would just amend on page 2 some existing statutes about the ability of the Wyoming Supreme Court to promulgate rules. And so you'll see that inclusion of the new section. And then the other parts of the bill are pretty conforming. Section 3 would say that this act shall apply to all persons charged with criminal offenses on or after the effective date. And the effective date would be July 1st. So to give you a little bit more background, though, about some of the concerns that I've certainly had, but I think that are workable and why this bill, I think, lands us in the right spot. In Wyoming, our Constitution prohibits the flat out denial of bail unless you've been charged with a capital offense. And so there have been instances where courts have had to look at whether bail has been excessive, or in other instances, bail was denied because of concerns about flight risk. Those are not permitted. However, it's important to recognize that our courts and judges have a lot of discretion to impose conditions on bail. And those can include anything, you behave yourself when you're out there on bail, or you could lose your bail money. And so that's what this is seeking to do, is not to deny a defendant outright bail, but to impose a condition for them to be released. And so that, with that, Madam Chair, that's the essence of the bill. I'm sure you'll have lots of questions. But I do want to make sure that if you have questions about the need and why this bill was brought, Detective Patterson would have an opportunity to speak. Thank you.
Thank you, Senator Ellis. Questions for Senator Ellis? Senator Ellis, can you tell us the difference between bail versus bond?
Madam Chair, no.
Thank you, Senator Ellis. Senator Ellis, I see that we actually don't, what we're really doing here is kind of kicking the onus to the Rules Committee of the State Bar. Is that fair? Assessment of what the bill does?
Sure, Madam Chair. And just to give committee members, I know our good chairwoman has practiced in criminal law. She does criminal defense work. As a full disclaimer, I don't practice in those areas. I reached out to Senator Nethercott several months ago and was hoping to get some of these concerns maybe fleshed out a little bit more. I apologize that we weren't able to connect and get some of those concerns fleshed out before we came to you today. So please know that with her expertise, with any concerns you have, I'm always happy to work on language. If there's concerns or limits you want to place on here, additional clarifying language that you want to provide to the courts, please know I'm amenable to any of those kind of amendments.
Thank you, Senator Ellis. For the committee's members concerned, Senator Ellis did reach out to me. I expressed concerns about the bill regarding Eighth Amendment concerns associated with the right to bail and bond. Significant work that the Supreme Court has done on this topic in the opposite direction of what this bill does, and primarily as a result of the overwhelmed court system that we currently have and how these hearings would occur, and really creating a very complicated, prolonged secondary hearing in a very important criminal type case, typically a felony. And so I just felt it was pretty cumbersome and didn't support the legislation. And so that's where that falls. So further clarification on that piece. Senator French.
Yes, Madam Chair. Senator Ellis, or the gentleman, sorry, I forgot your title. Forgive me.
Detective Patterson.
Detective. It starts on page 1, line 14, goes through on to page 2, 1 through 4. How do you determine that the proceeds are derived from a criminal offense or not? How do you determine that? Okay, that in the scenario you laid out that the one gets away with the cash, and then suddenly the other one is bailed out with a bunch of cash. How do you determine it was maybe not grandma or want to bail out her grandson? Or how do you make that determination that it was ill-gotten or it was the cash from the robbery?
Senator Ellis.
Thank you. Madam Chair and Senator French. Other states do this. And so evidence that they could show would be a grandmother, and you're nailing it right on the head. It would be a grandmother showing up with bank records saying, this is my bank statement and this is where the funds came from. So the intent isn't to create a pretrial trial. And that was my concern with this bill as well. We don't want to overload our courts, but we wanted to make sure that courts have this discretion. So we use permissive language saying that this is a may and not a shall, that courts do this. And if you wanted to tighten up the language a little bit further, you could add language, I'm guessing on page 2 in those first 4 lines, clarifying if the underlying crime involves theft or illegal use of money, that kind of thing. So I think there's room for improvement to address that concern, that I don't think you're going to see this happening in every case. I think it's going to be limited to those that are involved theft in large sums of cash, and wondering where that money came from. But I offer Detective Patterson, he has actually done some research on this, looked at how it operates in other states. And so I'd actually welcome him and defer to him for further clarification on what kind of documentation would be provided.
Detective Patterson, welcome to the Senate Judiciary Committee. Welcome. If you would introduce yourself to the committee and share with us your thoughts on the bill.
Yes, Madam Chairwoman. My name is Casey Patterson. I've been a detective with the Cheyenne Police Department for 15. I've been with the Cheyenne Police Department for 15 years. Been a detective for the last 2 years. Prior to that, I have service with the Laramie County Sheriff's Office here in Cheyenne. Essentially, I brought the idea of a bail source law to Senator Ellis in 2020, as a result of a case I worked involving subjects who were contacted and arrested for stealing from Sam's Club locations across the country. One of the subjects was had his bail set at $50,000 cash. A few days later, associates of his came from across the country to Laramie County Circuit Court with a duffel bag that contained $50,000 in cash. A few days later, the defendant in this case had been arrested with $25,000 in cash on his person. I could prove at that time the cash was stolen. He had no legitimate employment and no assets. He was also associated with known criminals whose only source of income was theft of jewelry, electronics, and cash. No questions could be asked by the prosecution into the source of the defendant's cash. So if he had been released and vanished, there would be no incentive for him to return to face charges of felony theft in Wyoming.
Detective Patterson, what happened to that $50,000?
So the $50,000 cash was taken by Judge Lee. They had to fill out a Form 8300, basically a CTR. One copy went to the Wyoming Supreme Court and one went to the U.S. Attorney's Office, which is apparently the practice that the Wyoming Supreme Court has set in place for the for incidents like this to happen. Judge Williams at the bond hearing also put a provision in this defendant's bond that he was to either surrender his passport or provide proof that some government had provided documentation that this person's passport had been surrendered to that other government. He was a foreign national.
So what happened to the $50,000, Detective?
The $50,000, I don't know what happened to it. Other than I know the court was essentially forced to accept it because there was no way to reject or question the source of that cash.
Did the defendant abscond?
The defendant was not allowed to abscond. Interestingly enough, he was unable to provide his passport or proof his passport had been seized. So he, in the meantime, the case went from state to federal. So it was enough to hold him in custody. And quite honestly, it took some thinking outside of the box to play within the rules, but be creative enough to keep him in custody so that he could be held and didn't abscond the jurisdiction of either the state or federal system in Wyoming.
Has he since been convicted?
He has been convicted 2 weeks ago.
Detective Patterson, had this law been in effect, isn't it true that that $50,000 of alleged drug proceeds would have still been on the street because it would have been rejected instead of within the court's authority?
Well, without knowing exactly where the cash came from and without being able to ask the questions, it's unknown and maybe not fair for me to speculate where that cash would have wound up.
Detective Patterson, do you have any experience with asset forfeiture?
I personally do not. And in speaking with Senator Ellis, we didn't want to incorporate asset forfeiture or any type of seizure as part of this bill. Rather, make it the court being able to say yes or no, we're going to accept this. Because we have concerns that this person's only source of income is from criminal activity. In fact, in U.S. versus Nebbia, one of the judges held that a defendant has no right to illegally acquired property. Thus, posting bond with illegally acquired property provides no security for the defendant's appearance. So it was really more of a question, does the court accept it or does the court not accept it? In the event the court does not accept it, it doesn't mean at a later time the court could accept. Let's say, for example, grandma does come along and pull some money together and is able to post a bond with legally acquired property, her money.
All right, questions for the detective. Senator Cooper.
On page 2, lines 6 through 10, it talks about documentation. Would this be documentation similar to what we might have to provide for down payment on a loan, or is it, what are you actually looking for there, Senator? Thank you. I'm sorry, Madam Chair first, and then Senator, is this similar to something you would provide for a down payment on a loan, or what are you actually looking for there?
Senator Ellis.
Thank you, Madam Chairman and Senator Cooper. I think this is purposefully left broad. As the detective mentioned, you have instances where individuals don't have bank accounts and don't have employment. So it calls into question where certain amounts of cash came from. But if a defendant had proof that they had a bank account that came from a savings account, a checking account, a pay stub saying, this is where my money comes from and this is how I paid this bond, those should be sufficient. And then to answer the question, I know that the good senator never asks a question that she doesn't know the answer to. So I'm sure she'll enlighten you, but my understanding is the bail is the amount that you have to pay to get out. A bond is when you lack those sufficient funds, so you have somebody else post on your behalf. And if I'm wrong, I happily will take the correction from the good chairman.
So Detective Patterson, what's the ultimate goal here? Is it to keep suspects incarcerated?
It's to ensure their appearance in future court hearings.
$50,000 isn't enough, Detective Patterson?
Well, not when they're part of an organized crime group where the gentleman who was with this guy was convicted in another country of stealing 11 million euro. $50,000 in this case with these people was not a lot of money to probably everyone in this room. $50,000 would be a big dent. But the ultimate goal is to ensure that the bail that's posted is honest money. It's not money that was stolen. It's not money that was laundered. It's not money with
Detective
blood on
Patterson,
it.
help me walk through how that
Sure.
overrides the Eighth Amendment to the United States
The
Constitution.
Eighth Amendment provides that bail cannot be denied.
Why is that important?
It's important so that people aren't held in custody unnecessarily for a crime they're not convicted of.
Senator Kolb.
Thank you, Chairwoman. Thank you, Detective Patterson. I had a question, and probably relates more directly to probably your side of the knowledge that you've gained.
Sure.
Specifically, the documentation issue. And, I'm in favor of this type of way of addressing this issue. However, there's the flip side. We've got the potential abuses. We've got people that may be not like you, who abuse this potential statute change. And how do you think this covers that? Because of the hearing, the documentation issue is really a broad statement. I think when you look at good people doing the right things, there probably isn't an issue. But if some folks that maybe are upset with somebody personally or have an axe to grind with them, and law enforcement would rake someone over the coals, basically, of trying to produce some sort of documentation that they feel is appropriate. And, I understand the need, and like I say, I'm supportive. But could you explain how we have some sideboards on this to stop that abuse from potentially happening? Thank you.
Detective.
Thank you. One of the first things I remember coming to mind and speaking to Senator Ellis about is I don't want this to become weaponized. Just like no law that's on the books should become weaponized to punish someone while they're already going through the system. And so I would absolutely be heartbroken if I found there was some person that was using any law that was on the books against someone for the intent of maybe having an axe to grind against them. I don't think that's fair to someone who's merely accused of a crime. That being said, I've got a couple examples of some real world cases here in which, people are found either they're pimping, they're stealing just large amounts of cash, be it a bank robbery, as Senator Ellis had mentioned, or maybe just a real world example. The Wyoming Highway Patrol just posted on their Facebook page from February 9th. Some people, I believe it was in Sublette County, were contacted, and they had nothing but they're from Florida. They had stolen credit cards on them. They had just all kinds of like forged checks and just all kinds of stuff. So they're obviously on a cross country crime expedition. And I would hope if this bill leaves this room going forward, that some very real guidance is maybe what you're referring to as to when it's appropriate, when it's absolutely not appropriate. It's not absolutely appropriate. For example, reality is a lot of people that their cases come across my desk, they're in a low, they're not doing well financially anyways. And so we wouldn't want to make their situation worse or make their family's situation worse by forcing them to go out and commit crimes, cut off catalytic converters on cars, for example, to try to save up enough money to get their family member out of custody pending further court hearings. Again, that being said, we can go back to the example of what just happened in Sublette County, or what happens almost on a monthly basis, where we see Highway Patrol does an interdiction stop on Interstate 80, and there's a little bit of drug paraphernalia in the car, but there's another duffel bag full of cash, and nobody knows where the cash came from, and just one of those kind of scenarios, if that makes sense.
Detective Patterson, that money would be seized, correct?
That money would be seized, but it doesn't mean if that person's arrested, maybe they have a warrant from another state, which happens. Okay, where's this other money coming from to bond them out? Again, putting the seizure and the forfeiture stuff aside is just an example of where would this person's source of bail come from? Is it from a legitimate source? If they have no employment history, they don't have any assets such as a house, their own car, they're in a rental car, which was the case in the first example I brought, where they had the $50,000 cash brought in. They were in a rental car and they're just moving across the country. So,
Detective Patterson, in those circumstances, doesn't the judge have the discretion, and the prosecutor can argue for a higher bail or even no bail at all? And in fact, the court is required to evaluate flight risk associated with granting of.
correct. And that usually, obviously, as everyone I'm sure knows, that happens at least the initial, and then the prelim is typically where bail is argued. I asked one of the prosecutors in my case that I was working if they could argue for this type. This is before I knew Wyoming did not have the ability to argue for a nebia type hold, which is what a bail source hearing is. I was told by the prosecutor, we can't do that in the state case, and we're not even allowed to argue about a defendant's ability to pay bond as a reason to seek a higher bond. So, I mean, they can argue about flight risk. Usually that's all based on their criminal history, is what I've seen, and maybe some local contacts we have with that person. So does that answer your question?
Madam Chair?
It does, Senator Ellis.
Madam Chair, just to kind of build on that. And the difficulty in bringing this bill is, how many sideboards do you want baked in here? You know, I'm aware of the courts having this discussion about where they want to go. And so we did afford them some ability to have this conversation. What are they seeing in their communities? What's the need for this? And so that's where it's purposefully left to rely on our courts to kind of sift through some of those issues. But when you talk about flight risk, you know, when they're debating how much, or not debating, but when the court's considering how much to set bail, if you have concerns that there's a flight risk, they can't just automatically deny you bail. That's baked into our Constitution. So what I think you'll start seeing is you can increase that amount, maybe 50, maybe to 100, maybe 150. If that money isn't yours, it doesn't mean anything. And so you can keep increasing that amount. I think this might actually have the opposite effect, that if you can show that this money came from your bank account and that $10,000 is real money to your family, to you, that it's going to be a really important factor in just demonstrating that you're not going to be a flight risk. But if the source of the money is obtained illegally, I mean, we're just going to keep kicking that number up higher and higher. And that was one of the conversations we had, and this is a value judgment for this committee and the legislature, is if someone walks away from that bail amount at 50 grand and they're gone, we will never see them again in Wyoming. Are we satisfied that we allowed them to leave knowing that the money they obtained came from likely illegal sources?
Senator Ellis, what happens to that money?
Yeah, Madam Chair, and so it's forfeited. And beyond that, I don't know the ins and outs of which account it flows, if that's your inquiry. But it's a question. Are we satisfied that you can essentially walk away and you walk away? And so that's more or less the price of your freedom. You never come back to Wyoming without risk of being arrested again. But that's a value judgment. Maybe that's okay with you. To me, it's not. And so that was my kind of thinking on how we have that discussion. And that's why I think understanding the source of where that money comes from really does get to that flight risk and what we're willing to accept and not accept, and maybe buying your freedom.
Senator Ellis, isn't it true that that money would be forfeited and there would be a felony national warrant for your arrest
Sure, absolutely, Madam Chair.
outside of the state of Wyoming?
So your freedom is with that caveat that you don't get caught in another jurisdiction. Absolutely. But that's my concern. And so that's the thing for us to ponder as a legislature.
Detective Patterson?
I would absolutely echo what Senator Ellis had said. $50,000 that is forfeited because someone fails to appear, a bench warrant then issued. In my case, I had 3 individuals who were Romanian nationals. And if they leave the country and Wyoming gets another $50,000 in its pocket, they really don't care if they ever come back to the United States or not. They came in illegally, and there's simply no incentive for them to come back for any future court appearances.
Detective Patterson, the feds took that case over, correct?
Yes, they were prosecuted federally.
Are you aware if the feds are pursuing any asset forfeiture proceedings?
They're working currently on restitution with the jewelry, coins, and the cash that was found on them.
Any additional questions? All right, thank you both. Is there any public comment on this bill, either online? Raise your hand if so. All right, seeing none, is there any public comment in the room? All right, seeing none. All right, committee, public comment is closed. Back to you. Moved by Senator Cost. Seconded by Senator Kolb. Discussion on the bill. Roll call vote on the bill.
Senator Cooper,
Aye.
Senator French,
No,
Senator Kolb,
Aye.
Senator Cost,
Aye.
Chairman Nethercott.
No.
Madam Chairman, Senate File 98 passes with 3 ayes and 2 noes.
Thank you. Madam Chair. All right, good senators. Senator Koch, you'll take over the committee.
The next bill for us will be Senate File 123. And I believe the maker of the bill, Senator Nethercott.
Thank you, Mr. Chairman. Good senators, you have lottery games Keno. If you look through the bill, there's very little that's actually going on here. Page 2, lines 8 through 10 is the onus of the bill. And it says, this paragraph shall not be construed to restrict the use of electronic self-service terminals for a statewide Keno game. And so the issue really that this bill is addressing is the lack of express statutory authority for the machines associated with what's already allowed in our state. So for clarity, you are not being asked to vote on whether or not we should have a lottery. We already do. And you are not being asked to vote on the game of Keno. We already do. What really is happening here is the ability to use these machines. One of the there was effort by the lottery board to move this issue forward before, and now it's come forward with exceptional speed as a result of the pandemic and the need to have kind of independent operators associated with the ability to play these games that bring in a significant amount of revenue for the state of Wyoming. So kind of a simple bill. It's my belief that they probably already could do this. But they do want that express statutory authority. And I think that that's prudent that they take that cautious and conservative approach, ensuring that every step that they take is approved by the legislature. With that, good senators, I'd stand for questions on this bill, but I would direct your attention to the fiscal note associated with the revenue increase with the bill. So fiscal year 2022, $375,000. And by fiscal year 2023, it will be 1.5 million, and an anticipated $1.5 million in annual revenue increase. Good senators, I'm not aware of any opposition to the bill, either from retailers or those that are authorized to do this, or anyone else who is interested in this particular issue. It really is just kind of a fix in our statute to allow for that express statutory authorization for this conduct. I do know there are members from the lottery board who are here and willing to provide more information and testify in more detail onto the ins and outs of the need for the bill and additional revenue that might be generated, but happy to stand for questions.
Senator French.
Thank you, Mr. Chairman. Senator Nethercott, would you run that by me again on page 2, line 8 through 10? Because you said the Keno games are allowed currently.
Mhm.
Can you run that through again for me, please?
Yes, Senator French. So we have the Wyoming Lottery, which was been in place for years now, I'm sure as you're well aware, including a multitude of games that the lottery board is allowed to offer, including Keno. What's unique about this is a game machine. So instead of having to go to the teller, to the clerk and purchase it, you can use the kiosk. And so it's a kiosk game machine that would be available. I wouldn't call it I guess it's a game, but a kiosk machine associated with that. So the bill says there's nothing in this paragraph to restrict the use of self-service terminals for the purpose of Keno. And that's all it does. So it's neither saying do it, it's neither saying don't do it, it's just saying it can be done. But I do believe that the lottery board intends to do that, and if so, and had it been in place before the pandemic, I think additional revenues would have been gained in a safer way, as opposed to the transactions between multiple people handing off cash and money with the terminal. And so 1.5 million.
Any other questions? If there's anybody in the online that is interested in testifying on this, I would like them to please raise their hand now. At this time, we'll also call forward those that are in the room that would be interested. Go ahead, sir. Both of you, if you need to. I would ask that you state your name and proceed.
Good morning, Senator. Thank you very much. My name is Matt Kaufman. I'm an attorney here in Cheyenne with Hathaway and Coons. I'm outside legal counsel for the Wyoming Lottery. With me over here is Mr. John Klontz, the CEO of the Wyoming Lottery. Senator, in response to the bill presentation, Senator Nethercott is exactly right. The lottery has been planning and developing the game of Keno for quite some time. For those not familiar with the game of Keno, it's what the industry calls a draw style game, meaning the player selects numbers just like you do for Powerball or Mega Millions. The difference in Keno is it's played on a shorter interval, so it's played more often. And it's usually a social game. In other words, because it's played on a shorter interval, people like to play it together. So we often see this game played in bars, restaurants, taverns, things like that. Traditionally, as Senator Nethercott said, most establishments have their ticket sales occur through the bartender or the waiters or waitresses. Obviously, with new COVID-19 concerns about human interaction. Also, there's just a concern sometimes with bartenders, restaurants, it takes their time to do that. So what this product provides an opportunity for is the lottery to place essentially a ticket dispensing machine in the corner of the facility where someone could walk up, swipe their ID, insert their cash, and get their ticket. It saves the bar or restaurant the hassle of having to have someone physically do it. The reason the lottery has asked for this clarification is there is a specification in the existing lottery statute that the lottery is not permitted to have games that involve physical contact between a person and a machine. So when you walk into a convenience store now and buy your lottery ticket, obviously you pay cash, the clerk punches in the numbers and you get your ticket. So the only difference here is no one is playing a game on this ticket dispensing machine. It's just a way for players to get their ticket without having to deal with the clerks or bartenders. As Senator Nethercott said, we have done this analysis years ago. There's nothing prohibiting the lottery from doing Keno now. And like I said, the lottery is planning to roll out Keno regardless. Research has shown though with these ticket dispensing machines, the revenue tends to go up because people use them more freely and it's just easier for bars and restaurants to administer. So with that, the lottery is attempting to roll out Keno in the most cost-efficient way and a way that returns the most amount of return to the people of the state of Wyoming. And that's why we're here today. We didn't want to bring a full handout, but just for the committee's review, here's a picture of what one of these ticket dispensing machines would look like. They're a relatively sleek, small machine that would just sit in the corner of a bar or restaurant. With that, Mr. Chairman, I'll stand for any questions.
Senator Cole.
Thank you, Mr. Chairman. Well, I'd like to see this in real life with the rays of light sticking out of it. I think that's pretty good. But on to the question, I guess I kind of came up with when you were testifying. Could you use these for the lotto instead of for Keno? Because I don't own convenience. I'm in the convenience stores as a businessman doing things. And I can tell you the clerk's time is consumed by folks coming in there with whatever type of ticket combination they wish to purchase.
Yeah, Mr. Chairman, thank you for the question. And I'll defer to the CEO, John Klontz, but the short answer is yes, conceivably these machines could be used for multiple types of games for ticket sales.
Thank you, Matt. Thank you, Senator Nethercott. Thank you, Senators. John Klontz, the CEO of the Wyoming Lottery. And again, yes, this particular ticket dispensing machine, our sole interest is convenience for the player to avoid the backlog that would be created, just as you suggested, especially in the new 170 to 200 locations and bars and grills. And when the hostess staff become overwhelmed, and we're going to sell less product. And we think we might even be able to double the revenue return with the use of kiosks because of the convenience factor and what we've seen from our research and other lotteries. Kiosks are used in many, many states in the C-stores, as you mentioned, truck stops everywhere for other products, but we run into this issue in the law that Matt stated. But Keno is a game that requires a lot of player education, and it is a fast play, fun game, and it will generate a lot of interest. And so the convenience factor is what we're after, so we can maximize the sales. But yes, you could put all of the games on a ticket dispensing machine if we were permitted to. That's possible.
Mr. Chairman,
Question to follow up.
are you
Go ahead.
currently permitted to do that? Putting, say,
No, sir,
lotto
Senator.
games?
This bill just is requesting the opportunity to use these machines just for Keno.
I look forward to seeing something that may advance our
I
convenience.
would love to see that, and maybe someday we might have some success at that. That would be a big deal for us too, I believe.
Thank you.
Other questions from? Okay, is there any more from either of you? Okay, is there anybody else in the room that wishes to testify? Not seeing anybody. I don't see anybody out online that has raised their hand. Is there anybody online that's wanting to testify?
Mr. Chairman, it looks like we have Mr. Wilcox here with us.
Okay. I see you in. Mr. Wilcox, would you please state your name and what you have to say for us?
Good morning. Thank you, Mr. Chairman. Jim Willix, Chairman of the Wyoming County Commissioners Association, and in full disclosure, also a member of the Wyoming Lottery Board, serving as a representative of local government on that board. The Wyoming County Commissioners Association previously supported a version of this bill. While we haven't taken this bill up because of the timing, we fully believe the Commissioners Association would be in support of this. As has been testified, it will increase revenue to local government, which of course is a needed thing in this time and age. And when you look at it as a simplicity thing, it really makes Keno a game that is widely supported and widely available. This also provides a revenue stream for our small businesses that would put these kiosks and or having clerks deal with the Keno game within their businesses. So it's a revenue stream, not only for government, but also for the businesses. And it's another fun thing for people to do. I could back up the numbers that both Matt and John said about how Keno is much more successful if we have the kiosks. And so both my hat as a Commissioners Association, we support this bill, and as a member of the Lottery Board, it is the most successful way to implement Keno. And with that, Mr. Chairman, I would stand for any questions.
Are there any questions? Okay, there's nobody else out there in the internet world. We'll close that. Is there anybody here? One more time. Not seeing anybody. Public comment is closed. What's your wish?
Move the bill.
Okay, it's been moved by Senator Kolb and seconded by Senator Cooper. Roll call vote.
Senator Cooper,
Aye.
Senator French,
Aye.
Senator Kolb,
Aye.
Senator Cost,
Aye.
and Chairman Nethercott.
Aye.
Madam Chairman, Senate File 123 passes with 5 ayes.
All right, good senators. Now we will go to Senate File 128, which is temporary delegation of parental authority. I did hear from Senator Kinski a confusing message about his ability to present the bill. Seeing that he's not here, I am guessing he's unable to present the bill this morning. There are also none of his co-sponsors here, but are there folks in the room who wish to testify on this bill? No? No? Okay. All right, seeing none, we will table this bill until we have an opportunity to hear it from the sponsor or any of the co-sponsors. So with that, Senator Kolb?
Madam Chair, I spoke to Senator Kinski, and he said he was in I believe, a JAC meeting.
He is in JAC every morning, good senators, but he does have a bill in another committee. So we will table the bill. So thank you for that, Senator Kolb. We will move on to good little bill, Senate File 66. Good senators, we have a great deal of time this morning. It is only 8:43, so we are moving through these bills with rapid speed. Senator Cooper. Got some good co-sponsors on this bill.
Good morning, Madam Chair. Thank you for recognizing me. I'm going to visit with you a little bit about Senate File 66. This is a bill that has a lot of gravity to me, especially. Senate File 66 is very directly applies the Slayer's rule to joint tenancy and other instruments of joint ownership of property. It comes to us in a very tragic situation. Slayer's rule says, and the good chairman will, I'm sure, correct me because I'm probably going to get it wrong, but it says that if you kill someone, you cannot profit from that. Unfortunately, in the state of Wyoming, somehow they missed that when they put together the joint tenancy rules, and for whatever reason, it's been overlooked. It wasn't applicable. So what this does is applies Slayer's rule to joint tenancy to really any other form of joint ownership with rights of survivorship. So that if this happens, the person who perpetrates a crime cannot profit from it, as it should be. So it's a real simple thing, but it's not. In the bill itself, on page 2, the heart of the bill is lines 5 through line 8. It says no person who feloniously takes or causes or procures another to take the life of another shall not inherit, receive, or otherwise take any property held with the deceased person in joint tenancy with rights of survivorship, tenancy by the entirety, or any other form of co-ownership with rights of survivorship. That's pretty direct. The reason we're hearing this today is a tragic situation, and there is a gentleman in the audience here today who'd like to testify to that, if that pleases the committee. Thank you, ma'am.
Senator Cooper, thank you. Any questions for Senator Cooper? Senator Kolb?
No, I do not have any questions.
All right, thank you, Senator Cooper. All right, we'll have you stay there, Senator Cooper. Do I have any public comment on this bill? If so, please come forward. And again, we have plenty of time this morning.
Set that right. Somewhere right there. Maybe.
There she is.
Picture of my daughter, Deidre.
Mr. Walker, welcome.
Thank you.
It's good to see you in person. I know it's a rough morning for you, but we really appreciate you being here. So if you would introduce yourself to the committee, identify who you are and why you care about this bill, we would be happy to hear from you.
Okay. My name is Mel Walker. I live in Wordland. And my wife, Darlie, sitting in the back here. I'll try to get through this, okay? February 15th of 2020, a little over a year ago, my daughter was murdered by her husband, who then went and shot and killed the family pets for maybe 5 dogs and a cat. And then a few hours later, shot himself. And through this ordeal of what it is, it has been just nothing but a nightmare to get through. We have, I'm probably going to be jumping back and forth here a little bit to get this all out in a clear picture. I don't know how much time I do have or what's appropriate, and I'm not always politically correct, so excuse me on that. We didn't know that anything had happened prior to getting a phone call Saturday night, which would have been the 15th of February. My wife got flowers from Deidre on the 15th, the day after Valentine's Day. The flower shop was busy. They sent them the day after. We got them on that Saturday. We tried to call and tell Deidre thank you and whatever, but no answer on the phone, which wasn't real uncommon for her not to answer her phone right away. So wasn't any red flags that were raised up at that point in time. We had let it go into the night, still not concerned for anything. We didn't know if they had gone out of town or what was going on. So about 10:30 that night, I got a phone call from my nephew who had gotten a phone call from, I believe, his sister-in-law. And the neighbors across the street had called and told her about this crime scene tape around my daughter's house. And he called and asked me if I had known what was going on. I said, no, I have no idea. So we called and no answers. We called Darren's phone, no answers. I called the police department and got no answers. Actually got hung up on 3 or 4 times because they couldn't give me any information. And granted, they had no idea who I was. Could have been anybody claiming to be me. Didn't help the case any, and I did tell them I was going to be in Casper and I'm going to find out what's going on. Finally, a detective called me back 2:30 in the morning, and he confirmed that there was 2 adults that were deceased in the house, along with family pets. Couldn't give me the names. We went to Casper the next day and talked with police chief in Casper and Detective Trimble. And they explained what they knew at that time. It's still under investigation. At this time, they suspected it was a murder-suicide. Didn't know all the facts on everything. There was still some question as to whether a third party was involved. Finds out later on that there was no third party, that was murder-suicide. The police chief tried to pass it off as a domestic violence. This was not a domestic violence case. There was no domestic violence involved in their relationship. They did have some problems earlier in the summer, got them worked out. There was never any domestic violence. So this was just an act of rage. Don't know why. Obviously had an argument of some kind. Prior to this, I'm assuming, and that's all that is an assumption. I don't know what went on. He picked her up from work. They went home and they were never heard from again. And so this murder, homicide, however, and I'm just going to share a few things with you that make it what it is to me. To me, it's wasn't a murder. I don't want to call it anything to lessen it. It wasn't a simple act of murder. This was an assassination on my daughter. She was put on the floor, on her knees. Hands behind her head, fingers laced together, where he shot her in the head multiple times. Severing fingers, thumbs, and serious trauma to her head. And I've tried to put myself in that position of hers. To know and to partially feel the sheer terror that she encountered in that few minutes' time. I can't fathom that. Can't even imagine. We hired, she worked for the municipal courts in Casper, and her boss was Judge Callie Lund. And all the gals in the office were pretty close, and they did a lot of things together. And they had known of no big problems with their relationships either that would have led to this kind of a ending. And we hired, back where I was going with that, we hired Rob hand-in-hand attorneys for the probate attorney for her estate. And we hired him pretty early on when this happened. I wanted to get things rolling. I wanted to try to get things done as quick as we can. We're quite a ways away from Casper, so it's not convenient by any means just to run back and forth, but not knowing how long this was going to take, we were advised by several attorneys and law enforcement officials that it was going to take a while. We were probably looking at a year or so to get this done. And Rob Hand had worked with Deidre in the job and in the system, and he wanted to take care of this for her, and so we hired him, and it's been good. The roadblocks that we have ran up against trying to get this done has just been unbelievable. We have done everything that we need to do by the book, by the law, and we have hit roadblocks after roadblocks with the attorneys from Darren's estate, which was her husband, and Tony Rowe, which is Darren's dad. So just so that's clear. And they have hired a couple of attorneys out of Casper that have put up roadblocks and tried to shut us down on every avenue that we go down to get things taken care of. And the small things of I had a car of Deidre's that we sold by the court's permission. We went and picked it up, took it to Orland, had it detailed, got it cleaned up, serviced out, sold it. A young gal that was going to college, and it was a nice car. And we got sidelined after the fact of selling this car to the fact of the attorney said the judge did not have the authority to make the decision to sell the car. The money is still in estate funds. It's not in my account. It's all the funding is documented. It's at the bank in Orland. It can be accessed whenever it needs to be accessed to see what's there. All the numbers match up. Nothing has been taken. The car is gone. And they say that the judge did not have the right to do that. So that's kind of where we're at with that obstacle right now after Rob puts together a 30-page rebuttal on this thing. We've had attorneys that have said one of these attorneys, made a comment early on that he has worked 3 or 4 of these murder-suicide cases, and he has come out on top every time. And trying to get us beat down to where we won't pursue it. He has said that since Deidre died first, that everything goes to Darren's estate because of this law that doesn't do us much good. I don't know why he would come up with something like that other than he did. Ruthless, very uncaring, rotten SOB. I would like to meet him, and I will one of these days. These comments I'm not a vindictive man. But these comments and remarks and roadblocks and hurdles stir a fire in me that I've never had in my life. I'm not going to quit. We're not going to back down. I will guarantee you they've never met the likes of me when it comes to this. The stress levels on my family and myself, we can't begin to tell you what that's like. Physical issues, and I've had teeth ripped out because I've ground them down to nothing. So I got to get new teeth. Jobs, that's our business has suffered a bit. Other, relationships with other kids and everything's good, but it takes its toll. There's always something there that is coming up to get in the way of something else. It's hard to explain that, but there are those other issues out there that need to be addressed, but then you can't get them all addressed because you're still working on this and we have no closure. I have no idea when I'm going to have closure, if I ever will, with this here. So the grieving process is hasn't even started yet, and this has been over a year. We had the investigation was done on this last year, towards the end of April, I think, March, April. Probably would have been April, but Detective Peterson from the Casper Police Department, he drove to Worland and let us know what was going on, gave us a lot of details about things that we didn't know had existed. And that was kind of kept quiet from everybody, just as a precaution. And they went above and beyond and out of their way, I think, to do an exceptional investigation on this. She worked with all these people. They all knew her down from the can't think of the name, but the gal that was in charge of taking care of the dogs and the animals. all the way through. I don't think there was any stone left unturned on this thing. I don't think there was any questions that weren't asked and that weren't answered. I think the biggest holdup in this right now are these attorneys that are fighting us on getting it settled and getting it taken care of. And I can understand if there would have been a car accident or something of the sort. My daughter died, Darren survived. I understand how that works, right of survivorship. I understand. This is not a right of survivorship with what he did. It was just the sheer act of rage for whatever reason. And whatever she did may not have been said in the nicest way, but she did not deserve what she got. And did not deserve that. He should have manned up and said, you know, I'm out of here. I'm going to go do what I'm going to do. You go do what you got to do. We'll split the sheets. We're on our own. He had no right to do what he did. I feel robbed on so many levels with this. Every day I come up with a new way to feel robbed. I have my daughter's gone. Any future holidays or birthdays or any grandkids in the future or you know, any other, even with Darren, any other days with Darren to go hunting or whatever, those are gone. Those were, we were close. I thought we were close. They've been married for 10 years. We did a lot of things together. That whole part of my life is gone, changed. It's just taken in a flash. You know, and I've got some great kids that you know, my wife has 3 daughters, and we got a boy that we adopted who was her biological grandson, and they're my kids. We do a lot together. We have fun. We go do things. We have issues. We have problems. And it works out. It's all good. She was my daughter. My bloodline stopped right there. It'll never pick back up. I don't know if, well, I will never get over this. It'll just have to heal as good as it can. Holidays, we've kind of wrote off Valentine's Day. That'll never be anything but a black mark from now on. Other holidays and special events will be slowed down and take a different direction on. It affects not only me and my wife, but the other kids, my mom, my sisters, our families, you know, Darley's sisters and brother. The support that we've had through this has just been unbelievable. I never would have. Never would have thought people could support people the way that we have been supported. But you go home at night and it's still what it is. Never goes away. And there's not any vast amounts of money in this account, this estate of Deidre's and Darren's. It's not a wealthy thing. Her possessions are still in the house that is getting foreclosed on. After a year, we can't even get them out of there. That's what we want. That's what we want to get taken care of. It should have been done months ago. This is the second winter now that they've sat there. We're paying insurance on the house, on the possessions in the house. So if something was to happen, they'd be taken care of. We've gone in and I say we, my daughters, my wife and I, and Deidre's friends and coworkers. We had some police officers that helped us from the Casper PD and stuff, that we went in and we inventoried the house, and we're just waiting for a sale of items, but that's never been approved yet because of the stalemate that these other attorneys have put on us. I filed a wrongful death suit with an attorney in Buffalo, Chris Wages, so I could slow this process down and get things lined out the way they need to be. We've thrown up some roadblocks for them also, but we've done it legally. We haven't called them names or slung mud at them or anything else. And there are times I wish we could, and I wish I could find the crookedest attorney in the world to get it taken care of, but that's not our way.
Mr. Walker, on behalf of the Senate Judiciary Committee, you have our sincerest condolences about the loss of your daughter and son-in-law over such a tragic event. Unexpected and shocking, and the horror continues each day. So as a co-sponsor of the bill, and we have discussed this issue, I'm happy to try to help and support and provide clarity so this doesn't happen to another family again. And hopefully we are making a difference for you and for those families affected by this. I know some of Deidre's friends are here to testify as well. I think they're up in Casper and they're going to appear on Zoom. So let's hear from them.
Okay.
They'll be up on the screen to your left or to your right. Welcome. Welcome to a difficult morning. We appreciate your courage and your time to be here with us this morning. I understand that you're friends of Deidre. We look forward to hearing your thoughts.
This is Deidre. Thank you. We have her here with us as well, Mel. Thank you, honorable committee, for allowing us to speak today and for taking the time to hear from us. We are asking for your support for Senate File 0066 to apply the Slayer Law to survivorship in cases of domestic homicide and otherwise. Wyoming's law is severely outdated, and this change would bring it in line with all other states in the 10th Judicial District that provide and discuss for survivorship in these situations. This change may not help Deidre's family immediately, but it can help protect future victim families. Okay.
My name is Erica Ketchum.
Oh, I didn't say my name.
Sorry, that's Sarah. It is February 15th of 2020. It's a dark, windy, and very cold. and I'm standing outside on the front steps of Deidre's house. The wind stops blowing and I can hear an officer talking on his radio. 2 deceased. My heart shattered as an officer came out of the house, headed straight toward me, and told me the 2 individuals inside hadn't made it. I asked if it looked like Deidre. The officer who worked with Deidre in the municipal court in Casper said, "From what I can tell, it is." Deidre Rowe was my best friend, my supervisor, and the favorite aunt to my kids. Deidre was the person who would give the shirt off her back or would send random flowers or a gift to brighten your darkest day. Many people who knew Deidre would tell you the same thing. She was amazing. She was also known for obsessive love for the color purple, playing bingo, makeup, and all things related to dachshunds. Everyone knew her dogs, Maya, Morgan, Dexter, Dawson, and their really large cat, Mowgli. They were her children, her babies, and her life. Deidre had big plans for her future, starting with the enrollment of the University of Wyoming to get a degree to help her with her future promotions at work. Buying a new house, she and her husband, Darren, had made plans and appointments to start having children, to start a family. Now I'm going to take you back to the day before Deidre's body was found. It was February 14th of 2020. I was blessed to see Deidre, not knowing that this would be the last and final goodbye. Deidre came to my house that evening with a gift for me and a warm hug for my 3 kids as they were wandering off to bed. They hugged her and she hugged them back tightly and told each of them goodnight. She stayed for a few minutes and we were laughing and giggling and having fun. And the 2 of us were just filled with cheer and joy. We were making plans to go out for drinks the following night. I walked her to her car where her husband was waiting for her, and I got to hug her tightly. In the middle of our tight squeeze, she said, "I love you, lady." And I responded with, "I love you too." And I watched them drive off in the direction of their home, and I waved at them, and I was giggling about how amazing my friend was. February 15th, 2020. It wasn't uncommon for Deidre to sleep in late in the afternoon. She was not a morning person. I sent her a text message later in the afternoon and still no response. Another concerned friend reached out, so I tried calling her with no answer. I tried calling her husband Darren again with no answer. I jumped off the couch and started shoving my feet in my shoes and grabbing my purse, and my husband looked at me in shock and said, "Is everything okay?" And I responded with, "No, Deidre and Darren aren't answering their phone. That's not like her. She's glued to her phone. I think something's wrong. I'm going to drive up to her house real quick and check on her." My husband felt my concern and grabbed his jacket and said, "I'm going with you." We drove to her house where another one of our friends was sitting there waiting for us to arrive. We pulled up into the house at Darren and Deidre's that they just moved into 2 weeks before, and all the lights were off, with both of their vehicles snugly parked in their driveway. We walked to the front door of that cold and dark night, and we pushed the doorbell. And my heartbeat quickened, and the chill in my heart took over as there was no response, and no dogs were heard barking. We peeked through the windows and we could see a single bedroom light shining down through the stairs. We started calling for both of them, screaming out their names, Darren and Deidre. We started walking around the house, checking the windows and doors and pounding on them, trying to get them, trying to get a response. We were pounding on the door in the front and in the back. And I decided to try the doggy door in the back, as they always left the door unlocked with 4 dogs and a large cat who enjoyed roaming in the backyard. I tried to reach through, and my hand hit a doggy door blocker, as if the house was locked down to prevent anyone from coming in or going out. This was not normal, and something was very wrong, and I decided to call the police to do a welfare check. We waited on the front porch of that cold and snowy day for the police to arrive. When the police finally arrived, they confirmed that Darren and Deidre's phones indicated that both of them were at the house. I reached over and pushed the buttons to unlock the door. We didn't do this earlier, just hoping someone would come to the door, but our hearts told us something was wrong and we should wait. We watched the officers make entry, and we could tell from the light shining through the window which room they were in. We continued to wait outside and heard the officers report 2 deceased were found in the house. My heart shattered. That officer came out to tell us there were 2 individuals inside that didn't make it, and I asked if it was Deidre. Again, the officer said, after working with Deidre in municipal court, from what I can tell it is. I melted into the officer's arms, sobbing, asking if all the dogs were okay, and was told from what they could tell, the animals had been killed too. It was later confirmed that Deidre had been shot and killed, and he also killed their family pets, the 4 dogs and their cat. He then ended up taking his own life. That was over a year ago. It was 387 days to be exact. That day is the day that Deidre's life flame was extinguished forever. Her family and friends have no peace with the passing and no answers as to why Darren decided to shoot her. To this day, 387 days later, her house is filled with all of her clothes, her personal belongings, her prized possessions, memories, and pictures just sitting there collecting dusts. Her parents and siblings do not have any closure as they're still in the probate battle for the belongings. My family checks on this lifeless house as her family lives out of town. During the warm weather, we go over and mow the grass. And now and then we check on the house to ensure there's no break-ins, surprise water leaks, or mice destroying or damaging Deidre's personal belongings. It's an eerie feeling to open the door to a cold, dark house, one that has this heavy chemical smell from professional cleaners that were used to clean up that gruesome day Deidre and her fur babies were murdered. We walked through checking each room, knowing this was the place Deidre and her fur babies were murdered, and that all the plans she had for her new house and a future with children were gone. Deidre did not ask to be murdered, yet we sit here every day watching the sun rise and set with the memory of her. Her family and her friends have no closure as we watch her life in the house collect dust rather than being shared with her family. Her family will never be able to hold Deidre again, but there is closure knowing her memories, personal belongings, and things she loved are with those closest to her and her family. I watched a father's heartbreak as I told him I was sorry. I could never give him the opportunity to hear her last unique and contagious laugh, give him that last hug, and let him listen to her say that last "I love you." No family should ever have to endure this loss this great. No family should get a letter in the mail from an attorney saying your daughter died first, so all her property belongs to her murderer. We are asking that you vote yes for the Senate File 66 Slayer rule applied to joint ownership. By approving this bill, you're supporting future families of victims of domestic homicide. There are families who are forced to deal with heartache and unexpected end-of-life planning in the event of a domestic homicide or domestic murder-suicide. The family should focus on healing from the loss and not fighting the legal battles to retain the victim's personal property. The only memories that the family may have left. Thank you for allowing me to have time to speak and for your consideration into the Slayer rule applied for joint ownership.
Thank you.
Ladies, thank you so much. It's so helpful to see how this kind of legislation can affect real people's lives, from Deidre's family and to those that loved her friends. I think she was very fortunate to have all of you in her life, and we are here to help and provide some healing, I hope. So thank you for being with us this morning and having the courage to share the story and walking through that. I know it was painful and something to dread. I'm glad you both have each other and are there together. Any questions from the committee? Ladies, thank you so much for being a voice for Deidre. Mr. Walker, thank you.
Thank you.
Senator Kolb?
Thank you, Madam Chairman. I just wanted to reach out to the parents, the father, and say, give my condolences personally. And thank you for coming down here to explain this. I don't know what it's like. I'm a father. I don't know what it's like to be in your situation, but my condolences once again. Thank you, sir and ma'am. And
Absolutely, yes. Please come forward so we can hear you. I know it's, people care about this issue.
I'm Mel Walker's wife, Darlene. And doing this will help. I know it's not going to help us, but knowing how Deidre loved other people, it would carry on her memory. It was so important to her. When we had her funeral, my daughters fly from all over. She had coworkers that she worked with fly from all over. And one thing that she always did was take the time to listen to them, where they felt like they were always her best friend. And knowing what we've gone through, I would never want to see a family so emotionally and financially exhausted from fighting the system. And we have discussed this repeatedly. If we have to sell everything to stand up for what is right, we will do so, because no other family should have to suffer through this. And I'm thankful that you would even consider changing this law that will help others in the future. Thank you very much.
Thank you so much. Thank you for sharing your thoughts. We appreciate you having the courage to tell her story. Again, I know just leading up to this day and the opportunity to testify is hopefully both healing, but I know very painful, just weighing on you. So we do appreciate it. Hearing your story has made a difference. And we thank you. All right, committee. Senator Cooper, is there a motion on the bill? All right, seconded by Senator Cost. Good committee members, I would make an amendment on the bill. I would move that on page 2, line 10. This act is effective immediately.
Thank you.
Is there a second? Seconded by Kolb. All those in favor, please say aye.
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 That motion has passed. Roll call vote on the bill. Senator Kolb.
A question. Why can't it be made retroactive? Is there a legal issue why that can't happen? And could that be explained?
Thank you, Senator
Madam Chair.
Kolb. Yes, I do think that there are issues associated with making laws retroactive, primarily as a result of concepts associated with, typically in the criminal code, called ex post facto laws, which is when you make laws retroactive, it creates an unfair playing field for how people plan and make issues, and it can really create more complications. Just imagine if we could make everything retroactive. So how would that affect other probate cases? Because it would be beyond just this case that you see now. It could be going back many, many years and undoing that kind of action.
So this would set a precedent, Madam Chairman.
I don't know that it would set a precedent as opposed to it would create complexity.
Well, Madam Chair, I would just like to say if it could be done, I'd be in favor of it. I understand the issues involved that would prohibit it, but I think in this case, I don't see why anyone should profit by murder. And so just my little statement. Thank you, Madam Chair.
Thank you, Senator Kolb. All right, roll call vote on the bill.
Senator Cooper,
Aye.
Senator French,
Aye.
Senator Kolb,
Aye.
Senator Cost,
Aye.
Chairman Nethercott.
Aye.
Madam Chairman, Senate File 66 passes as amended with 5 ayes.
Thank you, Judy. All right, I see that the chairman of the Joint Appropriations Committee, former President Perkins is here. Senator Perkins, welcome.
Well, thank you, Madam Chairman. Glad to be here.
Would you like to speak on any particular bill?
I came to, when you just finished up with the study on the Slater rule.
It was. Senator Perkins, would you like to provide some comments? We still have some time.
Well, sure, thank you. So I was trying to make it out of that meeting and into this one. So obviously I didn't hear the discussion. Did you do any, did you amend the bill at all?
We amended the bill to make it effective immediately.
Effective immediately. And then a couple of questions that I was looking at that bill last night and yesterday. A couple of questions. One, did you talk about the effect on the Slater rule of you're dealing mostly with co-ownership of property, but there's some other ways that property transfers besides survivorship. There's beneficiary designations, which oftentimes is life insurance, but there's beneficiary designations also for IRAs and other things like that that I'm not sure are covered under the bills it is now. There were also, there's also transfer, and the other thing that's very popular now is transfer on death or payable on death. And indeed, we already have, several, 6, 7, maybe it's 8 years ago, the legislature passed a transfer on death deeds. So they actually move real estate where there's no real co-ownership or present interest in the property, but yet it still is conveyed almost like a beneficiary designation on life insurance. And I was wondering, it seemed to me like maybe there was a gap there.
I will always call you Mr. President.
I get called a lot worse things than that. So.
Senator Perkins, great question. So when we look at the statutory section being amended, it's 214-101. And we did have a Slayer's rule on the books. And it does identify that under 214-101 subsection B, that no beneficiary of any policy of life or accident insurance or certificates of membership issued by any benevolent association or organization payable upon the death of any person who in like manner takes or causes, procures another to take the life of another, shall take the proceeds of such policy or certificate. So I do think that we have that particular life insurance, but I do think maybe there's some financial accounts. If we wanted to add in there, we certainly can.
There you go. Exactly.
So I look for that particular amendment on the floor if you would like to in a studying of this particular statutory section.
Well, and I apologize. I meant to get here and I had a couple amendments to offer, but you've already moved on the bill, so we can talk. But I didn't have the advantage of being here for the discussion. I didn't know if you had done that. And I just thought that maybe that was a gap. The other thing I wondered about as I read the Slayer statute was that the effect is that it now goes accordance with the laws of devise and descent. So the intestacy law is what controls that. And I was wondering, is there a reason why, or was there any discussion as you considered this bill about why that wouldn't follow a will or a trust or other, if there's something that goes out there, why it wouldn't necessarily follow that? Which would be the person who was killed, would be, kind of what their overall wishes was. But then to the extent that the person who killed them, the slayer, is included in there, that just passes as though that person predeceased the person that they killed. And I just wondered if there was any discussion about that at any point during the time I was thinking about that, but I didn't have the advantage of what you've had over the interim and your discussion, so I just would ask that question.
Senator Perkins, the bill did not come over the interim, and we did not hear any legal discussion on the bill. We heard testimony regarding the practical implications associated with families affected by this issue. So I do look forward to that and curious to discuss it with you further as to how you think, if a person did have a will, how that would operate now in the event the Slayer's rule would be triggered.
Well, and it just so happens I did one of those this year.
There's a lot of those going on in Detroit.
Yeah, it was the matter was, it was public. It was the young man in Commerce County that basically was drunk and ended up killing his mother for beer money. And so cleaning up after that mess. And that was her only son. And of course, he didn't contest anything. He's in prison. But anyway, as we went through that process, it ended up that in that case, it would not have made any difference because her will left everything to her son. So obviously he was not able to inherit under the Slayer rule. So but as you work through that, I just was wondering, and if you have any thoughts, I was thinking about why wouldn't that happen? It would be easy enough. For example, in that instance, if everything was left to the son under the will, but the son was the one who caused this felonious death, then obviously he can't inherit in that instance. So if it passes as though that person has predeceased, then what it means is it was like the son was already dead at the time the mother died. And so obviously the son can't inherit. And in that case, it wouldn't make any difference. The laws of devise and descent would be exactly the same as the will because there's no other provision in the will. But let's take another instance where let's say that there is a estranged son or daughter, or there is a son or daughter who has, maybe they're on Medicaid, maybe they're or maybe they've got a substance abuse issue and they're not the one who caused the slayer. Well, oftentimes in wills or trusts, you make provisions so that that maybe there's a trust to help this person out, but it doesn't disqualify them from governmental benefits. Or maybe there's a trust to help them out, but they're afraid if they get a chunk, a lump sum distribution, that it will feed their substance abuse habit, or other things like that. Or in some cases, you're trying to help grandchildren, and so they may be minors, and so they can't actually have money. So you have to figure out, you may have to create a conservatorship or things like that. So there can be instances. So in this case, where they had multiple sons, one of the children is the slayer, he's disinherited. It means his children may still get the benefit of that. Or if he doesn't have, in this case, a he, or could be a she, but if he doesn't have children, then it would most likely go to her other children. But all of a sudden, here comes a lump sum because it comes under the laws of devise and descent, where there's actually a trust or other provision made for them to help with that. And I was just, as I thought about that, it was like, if they've manifested what they want to have done with this property, and they've gone to the trouble to make a will or a trust, why wouldn't we as a state want to have a policy of honoring those wishes to the extent it doesn't advantage or create, doesn't create an advantage to the slayer, to the one who committed this felonious assault. So I didn't know what, and if the committee had some thoughts, I was just interested in that part of the discussion as I thought about how this applies. And because this is where I spend the majority of my practice is down in these types of questions.
Well, Senator Perkins, I think it works out just fine through the laws of intestacy if that slayer is removed from. I think there's a great question there of whether or not the slayer does benefit if it goes to his children.
It would under the laws of devise and descent anyway, though.
So maybe if that was his plan, that would be problematic. But we might be complicating it too far. I think if there was a child that was estranged, but was not omitted in a will, then that was a default in the will and that child would be allowed to inherit anyway, regardless of the slayer's rule. And I think if there was somebody who was under Medicaid provision planning, that they'd probably have to disclaim inheriting, and there's methods available for that.
Madam Chairman, disclaimers don't work anymore. Those are considered to be uncompensated transfers and end up with disqualification.
Well, they would need to contact you to create a special needs trust, Senator Perkins. Look what the lawyers did.
Yeah.
A special needs trust hopefully could accommodate for those concerns, but I look forward to hearing your amendments on the floor. To those family members who are paying attention to this, it would not alter any outcome, any of these discussions related to your concerns. It would only strengthen the bill.
Mm-hmm.
So I just want everyone to know that, okay? Senator Perkins, thank you.
Thank you. And I've got some thoughts, but I'll visit with you further because I don't want to mess up the work of the committee, and I haven't had the advantage of the discussion and testimony you've had. So I'll visit with you offline a little bit about that before I offer any of those, Madam Chairman.
Thank you.
Thank
Senator
you.
Perkins, appreciate it. All right, with that,